The 10:30 docket for January 29th, 2026 consists of one case. Appeal number 129260 in the matter of David L. Miller, original action and attorney discipline. Attorneys will enter their appearance.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office.
Chief Justice Rosen, members of the court, my name is David Rapp. I'm a lawyer from Wichita. I'm here representing David Miller, the respondent.
Thank you.
Your Honor, that concludes the docket for the week of January 26th through the 29th, 2026.
Mr. Shima, thank you very much. Counsel, if you're ready to approach with your argument, we're ready.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Mr. Chief Justice, I'd like to reserve 3 minutes for rebuttal.
3 minutes will be reserved, Mr. Vogelsberg. Thank you.
Thank you. This is an original action in attorney discipline involving respondent David L. Miller. Respondent was admitted to the Kansas bar in 2016. In November of 2024, the ODA filed a formal complaint alleging that respondent's conduct violated Kansas Rules of Professional Conduct 1.6A, confidentiality, 1.7A2, conflict of interest, and 8.4C, engaging in dishonest conduct. The matter proceeded to a hearing on January 23rd and 24th, 2025. At the hearing, Mr. Miller denied that his conduct violated any rules. At the conclusion of the hearing, the panel directed the parties to submit briefs on the rule violations. After both sides submitted their briefs, the respondent filed a letter with the hearing panel conceding that his actions violated 1.6A. The hearing panel filed its report on June 26, 2025. In its report, the panel concluded that Mr. Miller violated 1.6A by disclosing confidential information about client GM to another client DS. But the panel concluded that respondent's other actions did not violate 1.7A2 or 8.4C. In applying the ABA standards for imposing lawyer sanctions, the panel concluded that respondent had acted negligently when he disclosed confidential information about GM to DS. This conclusion, along with application of several mitigating factors, including the finding that the respondent showed remorse for his actions during the hearing, led the panel to recommend that respondent receive a public censure for his conduct. The ODA filed timely exceptions to the hearing panel report, challenging the panel's conclusions that respondent's actions did not violate 1.7A2 or 8.4C, that he acted negligently rather than knowingly, and that the mitigating factor of remorse was established at the hearing. Finally, the ODA continues to recommend, like it did before the hearing panel, that respondent's conduct should warrant a suspension ranging somewhere between 90 days and 1 year. I want to first spend my time this morning discussing why the evidence established that respondent's actions towards both GM and DS violated 1.7A2. Respondent learned from GM during a client consultation that GM had served as a confidential informant for the Wichita Police Department and had performed controlled buys of drugs from suspected drug dealers. GM identified DS as one of the drug dealers that he had performed a controlled buy on. Without asking for GM's permission, respondent later met with DS to determine whether GM was the confidential informant in DS's criminal case. During their meeting, respondent asked DS whether he knew who the confidential informant was in his criminal case. When DS indicated that he did not, respondent brought up GM's name and discussed with DS whether he thought GM could be the confidential informant. Respondent's disclosure to DS clearly revealed 2 things about GM. 1, that GM was a confidential informant, and 2, that it was possible that GM was the informant in DS's case. Respondent's disclosure to DS not only violated 1.6A, but it also violated 1.7A2 because the disclosure was clearly designed to benefit DS by allowing respondent to determine whether he could continue to represent DS despite his new representation of GM. Respondent's decision to disclose confidential information about GM to DS clearly shows that respondent prioritized his duty of loyalty to DS over his duty of confidentiality to GM. His disclosure to DS in no way benefited GM, giving that GM's legal issues that he consulted with respondent did not involve DS. Not only did response disclosure to DS violate 1.7A2 as it relates to GM, but respondent's subsequent actions after making his disclosure to DS shows that he materially limited his representation of DS in violation of 1.7.
What was the nature of the disclosure? Exactly how did that occur? Was it just directly that DS is the confidential informant in the case, or how did that happen to GM?
They had an in-person meeting and asked him, ask DS, do you know who the confidential informant in your case is? When DS indicated no, then that was when respondent brought up GM's name as a possible candidate for that role.
Was it a possible candidate or is the person?
From the evidence, it was possible.
Thank you, Mr. Vogel.
Respondent acknowledged in his written response to GM's complaint and in his answer to the formal complaint that after he disclosed to DS the possibility that GM was the confidential informant in DS's criminal case, respondent told DS that he would be filing a motion to suppress the evidence found in DS's home. Respondent, however, told DS that in seeking to suppress the evidence, respondent would not be, quote, seeking the identity of the confidential informant because that could put respondent in a position of a conflict of interest based on the possibility that GM was the CI. That statement establishes that respondent recognized that his representation of GM would conflict with his representation of DS if GM was in fact the confidential informant, because GM would be a witness at a suppression hearing regarding the controlled buy that he performed on DS. To avoid this conflict, respondent deliberately excluded from his discovery motion information that would have intentionally or inadvertently disclosed the identity of the confidential informant. By shunning discovery of the confidential informant, respondent materially limited his representation of DS. He did so without first obtaining DS's informed consent, confirmed in writing as required by 1.7B4. Accordingly, respondent, as a matter of law, violated 1.7A2 as it relates to DS. If there's no questions about the 1.7 violation, then I'm going to go ahead and move on to the 8.4C violation.
What's your, well, let me, I don't know if this comes under 8.4C or 1.7A2. Is your, as the rule applies, should Mr. Miller have just withdrawn because of conflicts with both at this juncture? It seems that way to me. I've just kind of standard criminal defense practice, this kind of, that would have been a course that could have been taken.
Once he received information from GM that made it indicate to him that it was possible that GM was the confidential informant in DS's criminal case, he should have first kept that information confidential and then withdrew from DS's case.
Why does he have to withdraw just on the possibility?
Because obviously when he then subsequently tells DS, I'm not going to be able to search for information or seek discovery of information about the identity of the confidential informant, he's materially limiting his representation at that point, where another attorney who doesn't owe any sort of obligations to GM would not feel the necessity to exclude from discovery the identity of the confidential informant.
So, but doesn't that expand the conflict rule into the realm of potential conflicts? I mean, a potential conflict is not a conflict, right?
I would say in this case, he treated it as a conflict by the way he conducted himself.
Yeah, the argument about limiting his representation because of a potential conflict is maybe a different rule violation, but it's not a conflict violation, is it?
I would still say it was a 1.78A2 violation.
Which
because-
requires there to be a conflict.
which In this case, there was. I mean,
Ultimately, there was, but I'm
conflict.
trying to be specific as to when respondent knew that there was a conflict.
I believe he knew there was a conflict when he was consulting with DS and determined that even after speaking to DS about the control buy that went down, that didn't eliminate in his mind that GM was not the confidential informant. And we know that because after they had their consultation, he tells them, I'm going to be filing a motion to suppress in your case, but I'm not going to be seeking discovery regarding the identity of the confidential informant because that could put me in a conflict of interest if GM turns out to be the confidential informant. And so he specifically excluded from his discovery request that information in order to avoid that conflict,
That potential conflict.
that potential conflict. But that still was a material limitation on his representation that was in violation of 1.782. And because he didn't receive informed consent from DS regarding that plan under 1.7B4, that violates 1.782.
I just look at standard 3, difference between suspension and reprimand, and I only focus on the violation that is agreed to. It looks to me like 4.22 and 4.23 under standard 3. One is suspension is appropriate when it's a knowing violation, and reprimand is generally appropriate when it's a negligent revealing of information. But really any doubt that this was a knowing violation? I mean, this isn't a slip of the tongue in talking to, in asking someone whether they're the confidential informant. You know, that would have to be knowing. Is that right?
That would be my argument.
So if we just focus on the admitted violation, wouldn't suspension be appropriate from your viewpoint? And I guess explain why or why not, just on that basis?
Under ABA standard 4.22, yes.
Yeah, I mean, without worrying about panel's determination about other violations or anything else, we just take what's conceded, you would still be able to get to your recommended disciplinary.
If this court agreed with my argument that the conduct, the violation of 1.6 was knowingly committed rather than negligently as found by the panel.
Was there other, maybe I'm confused by the record about the limitation of representation that you're alleging. Were there other possible explanations for that limitation provided in the record, such as the likelihood of prevailing on a request to disclose the CI, or relying on the fact that DS indicated that during the relevant time period, he didn't purchase narcotics from GS or G, sorry, get the initials confused.
GM.
Thank you.
I mean, that was the initial explanation for why Mr. Miller was not going to be seeking the identity of the confidential informant, was because he was worried that GM could be the confidential informant. And so he basically wanted to avoid a directly adverse conflict, because if you challenge the controlled buy and say it didn't take place within 72 hours of December 1st, 2020, you would necessarily, in order to establish that claim, would want to seek out the confidential informant and have them testify about whether or not the controlled buy went down within that time frame, or if it went down as described in the affidavit as well.
But after further investigation, there's information that suggests that he was not. I mean, at that juncture, his explanation, I'm just looking, did the panel was considering two reasonable interpretations from the evidence?
From the hearing panel report, it's unclear as far as with the 1.6 violation. or I should say the 1.7 violation, they resolved it by, in paragraph 60. They said, although the panel recognizes the potentially problematic nature of the situation, the panel does not find clear and convincing evidence established that the representation of both clients was directly adverse, nor that the evidence established a substantial risk that the representation of one client was materially limited by the responsibilities to another client. So how I interpret that, like, yes, I would concede that after he decided to exclude from his discovery request the identity of the confidential informant, that basically eliminated the possibility that the confidential informant would be a witness at a subsequent suppression hearing. But by doing so, he materially limited his representation of DS. He did that. Another attorney in the same position would not have felt compelled to do that if they had no relationship with GM. And so I just find, as a matter of law, paragraph 60 is incorrect. There was a 1.7A2 violation here. I see that I'm out of time. I would just address the court.
Go ahead, yeah.
Go ahead in rebuttal. So-
We've asked you some questions here. Go ahead and do your.
Oh, okay. I would just submit, I raised the 8.4C violation that was based on the conversation, recorded conversation between GM and Mr. Miller that took place on February 20th of 2023. Throughout that entire conversation, GM is asking him, how did DS determine that I was a confidential informant? He's repeatedly denying. I didn't say anything to him to give him that impression. That's an 8.4C violation. I would just submit the remainder of my issues on the brief, argue that a suspension between 90 days and 1 year is appropriate in this case. Thank you.
Thank you. Any other questions, colleagues? Thank you, Mr. Volkelsberg. Mr. Rapp.
Chief Justice Rosen, members of the court. Again, my name is David Rapp. I practice in Wichita. I'm representing David Miller in this unfortunate situation. We're here today primarily because David Miller made a mistake in his effort to avoid violating the Kansas Rules of Professional Conduct, specifically Rule 1.6 relating to protecting client confidential information. As David Miller has admitted, beginning with his response to the complaint filed by his former client, the complainant, he unthinkingly disclosed to another client, DS, his concern about having a conflict of interest if his client, the complainant, was the confidential informant, or CI, referenced in an affidavit supporting the application of a search warrant.
Let me ask
Which-
you a question. You're using the word inadvertently. I'm gonna go back to, I think it was Justice Biles who said, how can this be inadvertent? I mean, it was pretty intent, how could knowing, I mean, how is it not knowingly?
Was not, I would submit, Your Honor, that it's not knowingly done because David Miller had not thoroughly investigated the situation, the relationship between this controlled by, which the confidential informant participated in, and the charges against his client DS. The controlled by was never charged.
But what I'm saying is that it is so apparent, if I was DS, that GM is a confidential informant during that conversation. I mean, he knowingly divulged the name of GM. And how does that not breach the duty of confidentiality to GM that he's a confidential informant? And to me, at least, the impact of that is life-threatening.
Because he didn't need to even bring up the complainant's role in anything because the complainant's role was confined to making a controlled buy.
It doesn't have anything to do with the role or anything. Did he or did he not bring up GM's name to DS?
The answer is yes, we've admitted
Okay,
that.
and was that, but you're saying it was inadvertently instead of knowingly.
And inadvertently, accidentally, because he didn't think through what the situation was. He didn't need to even find out what DS thought or didn't
But
think.
he knew he was doing it.
He knew he was doing it, but he hadn't thought through the lack of need.
Would a reasonable lawyer in his position have done that? Have thought about it? Oh, wow, I am telling this drug dealer client of mine that another client of mine is a confidential informant.
He did not say that. He said, I needed to find
He
out,
did
is
say
it
that.
possible?
I mean, he didn't say it, I mean, you could definitely, a reasonable person would infer from that conversation that GM was a confidential informant.
That's not what he said. That's
Okay, what
he
did he
said.
say?
What he said was, is it possible? Is it possible? Because he was trying to find out if there was a conflict. Now, the problem, Justice,
What
is
does
that
that mean? Is it possible? Why would it even matter?
because of
Why would it matter unless he was conveying to DS that GM was a confidential informant?
he was trying to figure out if he had a conflict, because he had in his mind at the time, as he's testified, a case of, the defendant, I think his name is Jenkins, is a case that's cited in our brief. In that particular case, a lawyer took on the representation of the confidential informant and the person who was the buyer. Okay, and he was representing both of them. And he didn't recognize, but wait a minute, now I'm representing the confidential informant. I can't really cross-examine him as diligently as I need to.
Okay, but maybe that's 1.7 with conflict of interest. But in that case, did the lawyer tell the dealer, oh, I'm representing this other guy? Have you ever dealt to him? Have you ever sold drugs to him? Didn't infer that or imply that, his other client was a confidential informant.
Again.
I'm just
David,
asking whether the Jenkins case,
In the Jenkins case, that really didn't come up. The
Right.
court's ruling was that, look, you can't do this. You can't represent the confidential informant and the person that.
and how did he
was
find out in Jenkins that he was a confidential informant? That he was the confidential informant for his other client?
I don't know the detail of that.
Maybe a motion to suppress and asking for disclosure of who the confidential informant was?
The conflict arose and the discussion was about the fact that this lawyer was limiting his obligation to thoroughly cross-examine both parties by taking on the representation on both sides of the equation. In this particular instance, we submit that there would have been no conflict because the CI was involved in a confidential, a controlled buy that was not charged. In Jenkins, it was charged. It wasn't charged here. So what happened was that David could have.
Decided to charge it. Oh, you know what? We're going to add a witness to our witness list because now we have another incident. I mean, we know from his discussion with a DS that he dealt to a confidential informant.
He asked AS about the possibility because he was trying to clear a conflict. He shouldn't have even asked that because there wasn't a conflict, because these two parties had nothing to do with the other's case. The control buy that involved the complainant was not charged.
But he could have been charged.
Well, Judge, realistically, it couldn't be charged because the prosecutors in Sedgwick County don't charge confidential informants at the request of law enforcement officers because the law enforcement officers don't want to have their confidential informants disclosed.
Well, even in spite of that, the disciplinary administrator, Mr. Vogels, suggested that in order to avoid the conflict with the potential, that Mr. Miller limited discovery and wasn't going to pursue the identity of a confidential informant in the defense of DS. At least it's pretty standard that that request is always made. Might be denied, but that did not even ask. Is that what happened? I'm trying to figure out, is that what happened here? Was that part of the strategy to try to avoid conflict, but by limiting
There was
discovery?
no, excuse me, Justice, I
Yeah,
didn't
no,
mean to
it's
speak over you. There was no intent to truly seek the identity of the confidential informant.
Why not? That's always done. I mean,
Well,
I mean, that's just that's a standard procedure in a drug buy kind of case, to
Okay,
figure out where the information was had. And that's,
Justice, perhaps you were more successful, but my understanding of the situation is that it's almost never granted. You know, there's a process, as your Honor is probably familiar with,
could be.
what's called I think it's a Rovario hearing. Kansas case is Washington, State versus Washington, and the important language that I think that it comes out of State versus Washington is that, you know, what helpful information for the defense was going to be gained by the disclosure of the identity of the
And that's
what
why
relevant
they're
help
typically denied.
for the defense evidence did the complainant possess?
Yeah.
And we submit that he had none because he wasn't involved in the search that led to the charges against DS. All he was the person who conducted the controlled buy. A controlled buy, which, by the way, I'm sure your Honor understands, the law enforcement observed everything. They observed the dealer from the time he left his house to where he went for the controlled buy. They had already checked out the confidential informant. They made sure he didn't have any drugs available to him. They made sure he didn't go anyplace else. He went right to the place where they were going to do the deal. The law enforcement people then separately followed these two people to other places. They talked to the confidential informant. They got the drugs that he had purchased. They made sure that there wasn't any other opportunity for him to acquire those other than the controlled buy. They followed the DS back to his home. They saw and noted that he was alone when he left his house and he was alone when he returned. So they didn't need the confidential informant, number one, because there wasn't going to be a charge based on that. And number two, because the cops had watched everything. I mean,
Can I was just going to ask to clarify your evidence about during the respondents meeting with DS. Your evidence suggests that there was no disclosure by respondent that he had an attorney-client relationship with GM. He did not disclose that GM was a confidential informant, but the nature of the inquiry made that implicit, thus your position on negligence as opposed to a knowing.
that's it, just, it really is.
But it was an intentional inquiry to determine whether he had a conflict between the clients, right? That seems knowing to me. And just trying to say, well, I didn't intend the consequence, but that's a different inquiry than whether you went in and made those disclosures. That's all I'm getting at here.
And my suggestion to you is negligence is evident from the fact that if he would have just taken the time to look deeper into the situation, he recognized that he didn't even need to find out. Because these two people are in two different cases. And And I also want to point out, there's like 4 or 5 lawyers were involved in this matter early on, including the investigator, 2 investigators who appointed, myself, my worthy opponent, Mr. Vogelsberg, and David. And every one of us took the bait. And what I mean by that is confidential informant, red flag. Okay, what do we got to do? David was trying to figure out if there was a problem as far as the conflict goes. He did it. He fumbled in that effort by just saying, is it possible that so-and-so was the confidential informant? If he'd have taken the time to go through and do the analysis, which has happened since then, he could have recognized that there was no conflict. Now, I don't want to suggest that it'd be a good idea for lawyers to be getting themselves in these situations. That was not a good idea. And, what he did do is he brought up the name. He shouldn't have brought it up. That's what he has admitted from day one when he received the complaint.
Can I ask some follow-up questions on this state of mind question? But specifically tied to the panel's findings. So we have 3 possible states of mind here: negligence, knowingly, and intentionally. In paragraph 67, the hearing panel makes 2 findings about 2 of those states of minds. The hearing panel says he acted negligently. That's an affirmative finding of state of mind. And then also in paragraph 67, the hearing panel says did not act intentionally. So that's also an affirmative finding on negligence and intent. However, and this is my question, if you go down to paragraph 76, the hearing panel cites the state of mind of knowingly. So there's a disconnect in my mind between paragraph 67 and paragraph 76. And I wanted to just ask you and get your position on how we should evaluate that disconnect within the hearing panel's findings themselves.
There's, the question's been asked. He knew, and statement's been made. He knew he made the statement.
Yeah, I'm not asking you to opine or take a position on what his actual state of mind is. I'm trying to figure out what the hearing panel was doing. And is this just a mistake by the hearing panel? Is the hearing panel considering that knowingly and intentionally are effectively the same? What is going on here with these 3 states of mind?
And my only explanation would be to repeat what I tried to explain before, is that I think he knew what he was saying, but he acted negligently because he hadn't thought through the real problem.
Well, would you agree with me that the hearing panel never makes an explicit finding on the knowingly state of mind? The only explicit findings are with regard to negligence and intent.
That's it. And then,
And so I'll just, one more chance to answer the question. What should we do with the fact that there's this arguably a hole in the hearing panel report?
I think that you look at their decision and their finding that there was no clear and convincing evidence. And I was going to spend part of my presentation about going through the collection of abject lies.
Ask a quick follow-up.
Infested
Is
this deal.
the legal definition of knowing, is the knowingness relate to that a reasonable person would know the result of the action?
I was thinking that in one of the recent cases, the court said that you do something, you know that you're doing it, but I don't think that.
Well, if that were the standard, then every negligent act would also be knowing. I mean, people act negligently knowing what they're doing all the time. The reason it's negligent, arguably, is because number one, there's no intent to cause the outcome. But the reason it might not be knowing is that, that would never cross the person's mind. It's just negligent. Is that what's going on here?
That's what's going through my head and
Oh.
I just did not articulate it as well as Your Honor. He certainly did not mean to do any harm. He was trying to clear himself of a problem and avoid a conflict. But he hadn't thought through what the ramifications were. He certainly didn't intend to cause any harm to the complainant.
Mr. Chief Justice, may I,
Yes.
even though he's out of time? I'd like to focus just very briefly on 8.4C, deceit and misrepresentation. So when he, it's my understanding, I guess, that, he told GM, I didn't raise your name to DS. No? What is that? What happened? Because clearly GM was pretty upset after that conversation, right?
Well, remember, Justice, there were at least two conversations between GM and
Right, there was
Okay.
the first one where he's,
the first one, he brings it up to Mr. Miller.
right,
Mr. Miller explains to him that, hey, look, I didn't tell him that you were the confidential informant. I'll get a hold of him, find out what he's saying, and and tell him, if he's doing it to cut it out. Mr. Miller then gets a hold of DS and talks to DS. And DS says, I didn't post anything. I hadn't said anything, I had no problem with GM. Mr. Miller then goes back with GM and says, look, I've talked to Shealy, and he denies that he's posted anything. He's denied that he's told anybody that you're a CI. And of course, we have
so
the test.
he admits, I guess, that he told DS that GM was a confidential informant.
No. He did not tell DS that he was a confidential informant.
Well, no, but when he
What he
talks to
said, what-
GM,
When Miller talked to DS,
I'm sorry,
when he talked to DS, he asked DS if he was telling people that GM was a confidential informant, if he had posted anything on social media about it. And DS said, no, I haven't done any of that.
I haven't told anybody that he's a confidential informant because,
I don't know. I mean, that's what he testified later. I mean, when Shealy testified when DS testified at the formal hearing, he said he still didn't have clear evidence that GM was a CI and that David had never told him he was a CI. David related his conversation with
Okay.
DS to GM.
and I have not, I will admittedly say I've not read the entire hearing transcript. So thank you for that clarification. Thank you, Mr. Chair.
Yeah,
I-
Justice Walsh, yeah, go ahead.
Quick question about the record. And it kind of relates to Justice Standridge's question. It's my recollection that DS testified that Mr. Miller, even in the first conversation following Mr. Miller's first meeting with GM, DS testified that Mr. Miller never mentioned GM's name, had never mentioned GM's name.
That's what he testified about.
Okay.
And he was very vocal about the fact that he had never told anybody that GM was a CI, and he had his own motives.
Mhm.
His own motives were that he thought if he outed GM, that would not go well with the local law enforcement people. And he didn't want to have any more problems or any more dealings with them.
And I appreciate we're taking a very close look after the fact. And Mr. Miller, I appreciate all what's going on when you're in the middle of all this and trying to sort this out. But when you had and I don't know if I should ask you because you should have an opportunity to speak and I want to not deprive you of that, but so I'll just ask counsel. Once the inquiry is made to both clients about what did you say? Are you a confidential informant? are you posting stuff? Doesn't that just imply, it just seems to me that this is a situation where you have a conflict with both. As I've read through this, and I don't want to simplify it, but once it gets to that point, it just seems to me there's a conflict with both, you withdraw with both. That's typically what happens in when courts are appointing counsel, public defenders, there's a conflict, public defender, when these types of things occur, that's what happens. And I don't see how you're free of conflict from either one of them. And explain to me why I'm wrong about that.
Justice, that's a great question, and it's very fundamental, and it goes really to the heart of this deal. There was no conflict because they were in two different cases. The only connection between the DS case and the GM case was that GM had served as a confidential informant, set up a controlled buy. The results of that controlled buy were then used in affidavit by law enforcement to go seek a search warrant.
In lots of cases.
And the search warrant, the results of that search warrant is what was charged against DS. There's nothing, had nothing to do.
It just doesn't seem like that separates it. If law enforcement's relying on the credibility of GM as a confidential informant in the case against DS, how is that a separate case? I mean, it's a separate case, I know, on the buy or whatever the transaction is, but they're relying on the credibility of GM.
They relied on the credit. You know, they were.
I understand how all these work.
Justice, but
That's what they do.
again, it's a control.
Establish that you have some reliable source in order to get a warrant. I understand.
Well, my recollection is it was pretty thin as far as what the comments in the applications for the search warrant were as to the confidential informant. But, you know, I think we have to look a little bit at the idea of, okay, what was GM going to come in and testify about? You know, that's one of the things that disciplinary administrator says, well, hey, look, you know, this guy was going to come in and be a witness. Well, no, he wasn't. Nobody identified him as a witness. He wasn't mentioned. He wasn't on the witness list. Mr. Miller was trying to only find out confirmation of the date, some information about the date. He didn't care. Now, he did bluff the prosecutor by saying, well, you know, we can file a motion, as Your Honor's made reference to seek the identity of the CI, and I've done that in the past and been successful. That's all part of the strategy of negotiating a plea, and which ultimately they got things worked out and came out very well for Mr. DS.
Let me just ask colleagues if you have any more questions, because Mr. Miller, you're here. You have anything you want to tell us?
Yes, just very briefly. Not going to add a lot to my counsel's argument. Of course, I'll answer any questions the justices have. I just want to say 3 years ago, I admitted the 1.6 violation. And I am admitting that today, that I did violate Rule 1.6. I know there's been some discussion about whether that was knowingly or negligently. I believe that it was negligent, as the panel found below. I absolutely do not believe I had a conflict of interest, nor did I violate the Rule 8.4. But I'm here to tell you, obviously, you all are going to decide what the appropriate discipline in this case is. And my mentor taught me a long time ago, admit when you've been wrong and accept the consequences. And I'm certainly willing to do that. And whatever discipline the court deems appropriate, of course. Like I said, it's been 3 years. It's been a long time. The disciplinary process in and of itself serves some deterrence. And I can guarantee you, had I have it over to do it over again, I would have told GM to go down the road. And I can assure this court that that's not going to happen again. I have a firm. I'm a solo practitioner. Wife is my paralegal, office administrator. Got 2 investigators and some people that some part-time people that work for me. So whatever the case, I wouldn't have intentionally or knowingly put that at risk. Law is not just a job. It's a life for me. But again, I will accept whatever discipline the court determines is appropriate. And I'm certainly willing to answer any questions the justices have.
Any questions, colleagues? Ms. Miller, thank you.
Thank you.
Thank you, Mr. Rapp. Mr. Vogelsberg, you reserve 3 minutes.
I want to address counsel's argument that these 2 cases were unrelated, GM and DS's case. Okay, so November of 2022, Mr. Miller contacts Natasha Esau, the prosecutor on DS's case, and asks for discovery about the control buy that took place in DS's case, and made the comment about, Ms. Esau denied his request, saying, if I do that, I'm going to burn the CI. And Mr. Miller made the comment like, well, I have experience in litigating those issues and getting the identity of the CI. And so obviously that comment shows that getting the identity of the confidential informant, attacking whether or not the control buy went down as described in the affidavit was part of that strategy. But when GM comes and consults with him in January of 23 and conveys to him that, hey, I was a confidential informant for the Wichita Police Department. I performed a control buy on DS. There are subsequent conversations between GM and Mr. Miller that at least gives him the indication that it's possible that GM is the confidential informant. He proceeds to then speak to DS. They have a conversation, obviously brings up GM's name as being a possible candidate for the role of confidential informant. And then at the conclusion of that conversation, then says, well, I'm going to be filing a motion to suppress in your case, i.e. challenging the control buy that took place in your case to provide probable cause to get the search warrant for your house. But in doing so, I'm not going to be seeking discovery of the identity of the confidential informant. Right there is a material limitation on Mr. Miller's representation of DS in violation of 1.7A2. Justice Stiegel, you're asking about whether there was a finding of knowledge in the hearing panel report, and I agree that in paragraph 67 it's lacking. But I think with the other findings of fact that the panel made, I think that the level of intent that Mr. Miller acted with has to show that this was knowledge.
What is the legal definition of knowing in the context of attorney discipline?
So once we get past the violation, so we establish the violation, then what we're dealing with is how knowledge is defined under the ABA standards for imposing lawyer sanctions. And so under those standards, knowledge is defined as a conscious awareness of the nature or attendant circumstances of the conduct, but without the conscious objective or purpose to accomplish a particular result. And so I know it's a mouthful, but I'd say here, when Mr. Miller decides to meet with DS for the purpose of determining whether GM is the confidential informant in his case, he proceeds to question DS, do you know who the confidential informant is? DS indicates no, and then brings up, well, do you think it's possible that GM could be the confidential informant?
Is that what he's, first of all, is that what he said?
That
I
is,
thought at least from the hearing panel report, what he said was, did you ever sell drugs to GM?
in,
Not that those necessarily make much difference, but I just want to be
Right.
precise.
where that comes from, that statement of asking DS, he says, no, I don't know who the confidential informant is, and then he brings up the name. That comes from the formal complaint, paragraphs 19 and 20, that is describing his interview that he had with the two investigators that were assigned for this complaint. And so that is conveying what he told them during that interview. And then he admitted to those paragraphs 19 and 20 in his answer to the formal
And
complaint.
it's just, I don't have those in front of me. What do they say?
Is
What
that during the interview, he told them that he met with DS, asked them whether he knew the identity of the confidential informant in his criminal case. When DS said that he was not sure, respondent brought up GM's name. He brought up GM's name as a possibility of being.
Well, okay, I just want to be, bringing up his name could mean he asked, could GM be the confidential informant? Or it means, or he could have just said, did you ever sell drugs to GM? Again, I don't know that that makes a difference,
Right.
but you keep saying he said, could GM have been the confidential informant? And I want to know what were from the record, the best we can tell, what were the actual words that he used?
That was a paraphrasing from his interview with the
That's what
investigator.
he said, and what the panel report finds is that what he said is, quote, did you ever sell drugs to GM?
Right, but I think at the end of the day, I don't know.
That's different. I
it's-
mean,
I-
again, it may not make a legal difference, but
I,
when we're parsing these
Right.
states of mind about knowing, and seems to me that it could matter what the precise question was asked was.
But is it the ODA's position that the fact that the one question was asked immediately after the other, that you have to look at that in the totality? Do you know who the confidential informant was? No, I don't. Did you ever sell drugs to GM? You know, what is the, you know,
Right. I think when you look at the totality of the circumstances where he's having a meeting with DS for this purpose of determining whether GM's a confidential informant, obviously DS is coming to this meeting, not aware that's the purpose. And then he starts questioning DS about. do
He
you know
clearly
about-
violated the rule. He admitted it.
Right.
Because he disclosed confidential information, but
But my point is with the totality of the circumstances surrounding that establishes that he had a conscious awareness of what he was doing.
you think the panel found it was negligent. And why isn't that reasonable? In other words, that given the way this conversation went down, he didn't know in the moment that I just accidentally told this guy that my other client was a confidential informant.
I would.
Why
cite-
isn't that?
Right,
And again, that's the panel's finding.
right.
Why isn't that supported by the evidence?
Because the evidence indicates that there was a purposeful.
Well, he
question
knew
of
what
that.
words he was saying, but again, that's not what
But there
knowing.
was an intent to figure out whether or not GM was the confidential informant in DS's case. That
Okay.
was what, and I would cite to paragraph 20 of the respondent's answer. He says, quote, respondent emphasizes the importance of the context in which GM's name was brought up. Respondent was seeking confirmation from DS that GM was not the CIA because respondent wanted to avoid a conflict of interest. And so I think that statement shows a purposeful motive on
That's
his
not an
part.
unlawful purpose.
An unlawful
That's
purpose.
not, that purpose does not violate our rules. The rule violation is disclosure of confidential information. The question is,
What level of
did he
intent?
know that that's what he was doing? And he disregarded that knowledge.
Right.
And so I don't see how his intent to figure out whether or not he has a conflict bears any relevance on whether he knew in the moment, at the time he said the words, that he was revealing this information. Maybe he should have known. That's negligence.
With paragraph 20 of his answer, to me, that shows that when he's disclosing confidential information, He's doing it with a purpose. It was not an accident. He was doing it to determine whether or not.
Right,
GM
but
was
the knowing,
conforming.
would you agree with me that the state of mind element doesn't go to his purpose? It goes to the violation. It goes to the disclosure of confidential information. Of course, he had a purpose. He was doing something on purpose.
Right. But
The question is, was he disclosing confidential information on purpose?
yes,
I know your answer is yes, but
yes.
okay.
So,
I do have one question, Mr. Vogelsberg. I do notice in the record that that the respondent filed a proposed probation plan, but is that not something we can consider? I mean, I don't really, I know that, you know, you didn't recommend that, or ODA didn't recommend that, and then the panel didn't recommend that, and I don't even know if he asked for that.
at closing argument,
Yeah,
Mr. Rapp asked for an informal admonishment.
okay,
Obviously, they recommended public censure, and then in his brief, they accepted the public censure. So in my mind, probation, they're not requesting probation anymore. And then furthermore, under Rule 227, you're required to file an
Follow up, right.
affidavit.
Yeah.
No
Okay.
affidavit.
I
was
just
filed
I
with
just
the
want to
court.
clarify. Thanks.
Any more questions, colleagues? Yes,
To clarify.
Justice Walsh, go ahead.
So there was a probation plan, and at the hearing, I recall there being testimony about how the plan was being worked. Is that accurate?
At the time of the hearing, yes.
And is that still happening, or do you know?
I don't know.
Okay, thank you.
Any other questions? Counsel, thank you for your arguments this morning. This matter will be taken under advisement.